you. To introduce John, because he's a neighbor in our university neighborhood that I happen to think is the best place in the city to live. But just to give you a brief background, John is an Idaho native. He was born in Pocatello, and he's been a long-time MyScout resident, where for a number of years he was the dean of the university's law school, and in 2013 and 14, he stepped in and was the interim president. Upon retiring, he received Emeritus status, was given this Sheldon Vincent Award for exemplary service, was awarded an honorary Doctor of Laws degree, and has had a classroom in the College of Law Boise School named after him. He received his undergraduate degree magna cum laude from Harvard, his JD law degree from the University of Chicago, and his Master of Laws degree from the University of Virginia. Before embarking on his legal career, he attended the U.S. Army's Command and General Staff College and served as the academic director of the Army's Judge Advocate General School. When he retired from the Army, he retired from the Army as a colonel and was awarded the U.S. Armed Forces Legion of Merit. Before assuming his role here as dean of the law school, he also served as the dean of the Louis D. Brandeis School of Law at the University of Louisville. In addition to his academic legal career, he has been a judge of the Shoshone Venonat Tribal Court and served as one of the original judges of Idaho's Court of Appeals. In retirement, he remains an active speaker in programs of continuing legal education, judicial education, and civic education, emphasizing ethics, the rule of law, and the role of an independent, impartial judiciary in America. And given our current political climate, we are extremely fortunate to have him talk to us today about the importance of judicial independence and impartiality for our democracy. And after his talk, he will give entertaining questions.
Thank you, Barbara. It's 1787 in Philadelphia. Curtains have been drawn back. The windows of the Council Constitutional Hall. Participants in a constitutional convention are emerging. And Franklin is one of them. And a woman named Mrs. Powell steps up on the street and says, "What have you given us?" And as you know, Franklin's timeless response was, "A republic. If you can keep it." That's our challenge today. What kind of republic was Franklin thinking about? And what did that Constitutional Convention deliver to us?
Excuse me.
Okay. Can you hear me? I think you can hear me without.
No. Keep your mouth closed.
Thank you. Well, what kind of republic was delivered to us in Philadelphia in 1787? The ordinary and bare explanation of a republic is a representative democracy. But it was more than that. It was a structure of government with vertical and horizontal dispersions of power. Vertically, from the states and even localities up to a national government, and horizontally across three branches of government. Now, the idea of hierarchy, the idea of horizontal dispersion, was not an entirely new idea in 1787. But something else was added. An independent and impartial judiciary, and that was unique in the world. In most countries in the world then, and in many countries of the world now, judges were simply part of the administrative apparatus of the state. They were civil servants. They were not expected to be independent at all. They were charged to maintain this structure of enumerated rights that came with the Constitution and its original 10 amendments, partly through the dispersion of power to prevent tyranny over the many by the few, and also to prevent tyranny of the few by the many, so that even the majoritarian impulse translated into the legislative branch, and to some extent into the executive branch, could not overbear certain fundamental rights that citizens of the states would have in this new government. That is the kind of republic that was delivered, and which we were charged by Franklin to keep. Both George Washington and Ben Franklin spoke about the necessity in this new kind of government for citizens to have virtue. They talked about the virtues and well-informed citizenry. Citizens, granted, it was a narrow view of citizenship in those days. Women did not participate, but all who did participate, and those who came later, were expected to be able to make up their minds, and not simply to be overwhelmed by groupthink. Political parties didn't even exist in 1787. They came later, for better or for worse. This government, with its dispersion of power and its hierarchical separation of powers, was to be safeguarded by a judiciary unlike any other in the world, independent and impartial. Now, oftentimes in popular discussion these days, we hear about the independence of the judiciary. But I wish every time I heard the word independent that it would be coupled with impartial. Because that is the idea of 1787. Many folks suspect, or I should say are suspicious of, the independent judiciary because they don't understand the impartiality aspect. And they think, well, if I don't agree with something that the legislature, the Congress has done, or something that the president has done, and the executive branch, and I'll just go to the judges, the independent judges, and get them to disagree. That is not what the courts are there. The courts are there to uphold the rule of law. And that was another new idea. In 1787, around the world, if you had used the phrase rule of law, people would have thought you were talking about the law of rulers. And some people still think so. But that is not what was delivered to us in 1787. Alexander Hamilton, one of the great framers of the Constitution, was an exponent of this independent and impartial judiciary. He said that it's one of the most valuable of modern improvements in the practice of government. It will be, he predicted, an excellent barrier to the encroachments and oppressions of the representative body, that is, the Congress. He said that the independence of judges may be an essential safeguard against the effects of occasional ill humors of society and against injury to private rights in particular classes of citizens by unjust and partial, as opposed to impartial, laws. He continued and said that courts would be obliged to pronounce void any laws enacted in violation of the Constitution. Now that was a very new idea. Imagine that people elected to the legislature, people elected to the electoral college, to the presidency, could somehow be constrained by a piece of paper. Who ever heard of such a thing? But the courts would be obliged to give life to that written Constitution. Hamilton went on to say that the judges did not have free rein to simply rule as they saw fit. They're bound by law. A voluminous code of laws is one of the inconveniences necessarily connected with the advantages of a free government. To avoid an arbitrary discretion in the courts, it is indispensable that they should be bound down by strict rules and precedents. Sometimes folks think, I've heard them say it to me, why do you have to follow precedent? Why do you have to follow all these rules? That's a little jargon of lawyers, it's technocratic. It's not democratic. Yes, it is. But it's a democracy in a republic that has the independent and impartial judiciary, the great innovation of 1787. Now, since that time, the idea of a rule of law has acquired some international following, although not unanimously. The World Justice Project, which emanated out of the United States, the University of Chicago, among other institutions, said that the rule of law is characterized by government officials, private individuals, and public and private entities all being accountable under the law. That's the phrase. Nobody is above the law and his counterpart. Nobody is beneath the law. This was partially presaged by the Magna Carta, the idea of people being bound by law. Because, in 1215, over 800 years ago, the aristocracy of England came down and said, here are some rules that we'll all agree to abide by. But nothing as comprehensive as the Constitution of 1787. The World Justice Project has also told us that laws must be clear, that's a challenge, publicized, no secret laws, stable, not radically moving from one administration or one Congress to another, just, and applied evenly. The way I say it is, we should not have in judicial decisions tickets for one train only. Everybody is bound by the decisions, and the courts themselves must be bound by their own decisions. The processes by which laws are enacted and administered and enforced has to be accessible. Everybody must know about it and everybody must have a relationship with it. They must be fair. And we hope our democracy usually lives up to that standard and efficient. So, for example, the Fifth Amendment, part of the original Bill of Rights, and the 14th Amendment came immediately after the Civil War, provides guarantees of due process to everybody. It doesn't even say citizens, so every person is entitled to due process, which means if the government is going to take some action affecting your rights, you're entitled to notice, you're entitled to opportunity to be heard, and you're entitled to a decision by an impartial decision maker. Not everybody agrees with that these days. That's the idea. And the 14th Amendment, all states are required to afford to their citizens and persons the equal protection of the laws. Moreover, as the World Justice Institute tells us, in a rule of law system, justice is delivered by competent, that is, people learned in the law, ethical, and independent, there's the judicial independence idea, representatives and neutrals, there's the impartiality idea. This underscores the importance, even today, of judicial selection systems and judicial retention systems that attract and keep people who can live up to these standards. Well, judicial independence, with its impartiality corollary, has always had its detractors. People don't like it. Or at least some people don't sometimes. In 1805, Thomas Jefferson, who, as many of you know, did not write any part of the Constitution. He was in Paris, France, in 1787, serving as our diplomat, we call an ambassador today, to France from the United States under the old Articles of Confederation. He was really not a fan of many of the things in the Constitution. He was a great fan of the Declaration of Independence, of course, and is rightly known for it. But he became quite annoyed in his first presidential term by some of the decisions of the Supreme Court. And in 1805, he kicked out one of the members of the Supreme Court, Samuel Chase, and said, I want him impeached and removed. Why? He didn't like the decision. How dare this court act independently, and how dare members of the court speak against the president? But that effort to impeach and to remove, remember, impeachment is the accusation made in the House of Representatives. Removal upon conviction of the impeachment happens in the Senate. That didn't happen in 1805, and it kind of set a precedent of its own, that we don't easily try to impeach and remove judges because we simply disagree with their decisions. There is an appellate process for that. We've seen other attacks upon judicial independence and impartiality, too many to mention here, but in South Dakota, as some of you may recall, going back quite some period of time, there was an effort to enact what was called jail for judges. That is, if judges issued opinions that were unpopular, the population could, through a specially appointed prosecutor, prosecute them for crimes of issuing wrong decisions and put them in jail. Jail for judges. It didn't quite make it, but it attracted a considerable fall. In Iowa, more recently, by recently I mean within the last 20 years, there was a movement which was successful to remove judges from the Iowa Supreme Court, because the Iowa Supreme Court had said under the state constitution, the rights of gay people could not be denied. That was part of the equal protection of the laws written into the state constitution and echoing the 14th Amendment to the federal constitution. Now, of course, you could change the constitution, but that's too much like work. It's easier to change the judges. And that effort was made and successfully done. Judges who ruled according to the Iowa Constitution lost the next election. In Montana, right next door, efforts being made to undermine the independence and impartiality of the judiciary by various methods, one of which has actually been followed elsewhere in the country, in some states, to make not only judges subject to election, which we have in Idaho also, but to make those elections partisan. So the judges have to appear on a ballot as Republicans or Democrats or independents. Now, of course, that gives short shrift to the idea that the judge once on the bench is supposed to be impartial. That's a popular idea in some segments of our society today, and there are even spokespersons in Idaho who are saying it's time for that in Idaho as well. Thus far, it has not happened. The true meaning of judicial independence is not freedom to follow the judge's own personal predilections. Judges aren't like Sancho Panza sitting on a donkey and just issuing decrees right and left, according to the story about the man of Lamont. The problem with Sancho Panza was he was actually a very wise source of basic wisdom, but it could change a bit. It could change from minute to minute depending on how Sancho felt. That's not a judicial system. Freedom in the judicial independent sense is free to follow the law, not necessarily to be answerable to others, except through the appellate process. In the old Soviet Union, there were courts, looked very much like ordinary European courts. But the judges at the end of any hearing would get in touch with the local political party leader, top party leader, and say, how's this case supposed to come out? That was the Soviet system. Our judges are expected to be, and are duty bound to be, impartial. And impartial and independent courts are, as Justice Hugo Black said in one of the great passages in the Supreme Court opinion, that the courts must stand for the rule of law against any winds that blow. But those who like the direction of the wind don't like that. Even though the direction of the wind may change from time to time. Law without a going backwards here. All right. Law without a fair and efficient judiciary cannot deliver justice. So the courts depend on the rule of law, but the rule of law depends on the courts. So, for example, after World War II, when India became independent of British rule, under the charismatic leadership of Gandhi, a court system was established following many of the old colonial structures, but it was overtaken by bribes and backlogs. Those backlogs still exist. I did a study a few years ago, and the average civil case in the higher courts, what they call high courts in India, took about 25 years. So what happens? People bargain, and the powerful overwhelm the powerless because there is no time. The situation has only gradually improved since then. The courts will fail our promise of the rule of law if they are not independent and impartial, even though they exist. So many people ask, how did things go so far wrong in Germany? In the 1930s, weren't there courts? Weren't there lawyers? How did the Third Reich displace fair and impartial administration of justice? Well, it was simple. They just created new courts and gave all the jurisdiction over major questions to the new courts. The old courts were pushed aside. Similarly, in China, in the 1960s, under law, even to minorities and to other persons unpopular at the moment. Think about who's unpopular at the moment. And whether you think you and your neighbors down the street would agree with a court that afforded equal protection of the law to that unpopular group. It's not easy. The American system is not easy. We hope the judges will rise to our expectations. They should meet standards of qualification. They should have substantial prior legal experience, integrity, including the strength of character, to be impartial even when others are tugging at their sleeves and saying, don't you dare. Professional competence, intellectual capacity, judicial temperament, civility, and a commitment to fairness. That's what we should be looking forward to. Not how are you going to rule in a particular kind of case if you are on the bench? What is, are you going to pass my litmus test? I'll say more about litmus tests
In a moment.
when I talk about the federal selection system and the state selection system. But one of the individuals who emerged from the federal judicial system, as you know, is a member of the U.S. Supreme Court now, Neil Gorsuch. Very good words. He said in a chapter of a book that he wrote after he was confirmed to the U.S. Supreme Court, by the end of it all, meaning the judicial process, I came to realize that some today perceive a judge to be just like a politician who can and must promise and then deliver policy outcomes that favor certain groups. They see the job of a judge as less about following the law and facts wherever they lead, and more about doing whatever it takes to help this group or stop that policy. And it struck me, just of course he goes on to say, it's one thing to worry that some judges might aggrandize their personal preferences over a faithful adherence to the law, but it is another thing to think that judges should behave like that. As the confirmation process unfolded, he said, I came to worry that our civic understanding about these things, about the Constitution and the proper role of the judge under it, may be slipping away. As you know, Justice Gorsuch is broadly characterized as a conservative and kind of under the thumb of the current president. But he was one of those who voted differently on the terror issue 3 days ago. And anybody who studies Native American law, the rights of tribes and the rights of individuals in tribes will speak to you very favorably about the jurisprudence of the Gorsuch. Nobody can be simply characterized if you're looking for intelligent, independent, fair-minded people. In Idaho, in our own state, we have a remarkable provision in our Constitution, state constitution. It says that justice shall be administered without sale, without denial, delay, or prejudice. That's a statement of the rule of law administered by an independent and impartial judiciary. It's in our Constitution, and every decade since that Constitution was written, somebody in the legislature or somebody in the executive branch has been really irritated by that. Since 1967, Idaho judges have been elected, but fortunately, and still today, they're elected on nonpartisan ballots. Vacancies in the office of district judge, which is the higher level trial court, the Court of Appeals, on which I serve, and the Supreme Court, are filled by appointment using a merit selection system. I won't go into the details about it, but panels, lawyers, non-lawyers, judges, review applications to serve in Idaho's courts, and they send a list of qualified names to the governor for appointment. Now recently, because the Idaho Supreme Court issued a couple of decisions that the legislature did not like, having to do with initiative, among everything. They said, well, we want to give the governor more power and not be so constrained by these merit selections. So, Years ago, they amended the statutes to say that the governor could reject a group of nominees from the Judicial Council, as that panel is called, and ask for more names. Well, even our government, who've been pretty good on this system, were a little bit puzzled by that, because they knew this was going to increase pressure on them to pick the right person, not just to pick a merit selection-based system, individual. The American Bar Association has promulgated ethical standards for judges, which then have been adopted by the states and by Congress for the federal courts. The preamble to that ABA model code of judicial conduct says that an independent and impartial judiciary is indispensable to our system of judges. It goes on to say judges must perform duties with diligence and impartiality, and even goes on to use the phrase without fear or favor, with which journalists are well acquainted. Judges shall recuse, that is, step aside, shall, when their impartiality may reasonably be questioned. You won't find that in many other countries of the world, where judges can ask to step aside because they have prejudged the case, or they have a connection to particular litigants, or must answer to a powerful political figure. But that's the standard, if we can keep it. Judges shall recuse when their impartiality may reasonably be questioned, and they must avoid even the appearance of impropriety. Not just actual impropriety, but the appearance of it. And must avoid improper ex parte communication, that is, communicating just with one side or the other in a case, rather than communicating with everyone and being public. In these ethical foundations, we find also that judges must refrain from making pledges, promises, or commitments on issues pending or impending in the court. Some people didn't like that idea. The judges have to refrain from making pledges, promises, or commitments. Said, well, that's a violation of the First Amendment right of judges. In a case called Caperton versus Massey Cole, the Supreme Court said, well, the First Amendment does not overcome the duty that we have to maintain fair and impartial. Less publicized but also important decision. The Supreme Court upheld against another First Amendment attack a prohibition against judges personally soliciting campaign contributions. Now that's not a completely effective thing, because judges can have a third party go out and solicit money for them. And more importantly, special interest groups can raise money and buy advertising for or against judges or for or against candidates for judicial appointment. And anytime there's a U.S. Supreme Court vacancy, you can be sure that a lot of lobbying groups are going to be pouring money into the media, either favoring or disfavoring somebody who might be nominated by the president. So it's not a perfect system, but at least the judges are supposed to stay away from it. In the federal system, we have a nomination by the president and what we call confirmation by the Senate, and those judges, in what we call the title, the Article 3 judges, Article 3 of the Constitution, they serve for life. Well, that's not quite right. They can be removed, they can be removed for misconduct, although that seldom happens. But the process has become increasingly partisan. Many of you who have looked in on Senate Judicial Committee hearings, you're just addicted to C-SPAN at 2 in the morning, go ahead and read them. Some of them can be unfortunately quite entertaining, because you have members of the Senate who are preening and posturing for their base or for president or against the president on judicial appointments. It wasn't always quite so straight. About 30 years ago, there were two gifted intellectual people appointed to the U.S. Supreme Court, Justice Scalia, Justice Ginsburg. They both were confirmed with more than 90 votes out of 100. But more recently, two other nominations, also gifted, very smart people, barely made it through. 50 votes each, against 48 with a couple of people not voting, Justices Kavanaugh and Amy Coney Barrett. Why? Because the stakes are so high and partisanship is so rampant. Just 30 years or so have separated us. Two justices could hardly have been different in their jurisprudence than Scalia and Ginsburg. But nevertheless, they were all confirmed because of their ability. Today is different. In the state system, like Idaho, we have widely ranging methods of judicial selection. Ours is one of the best. We do have merit selection panels called the Judicial Council. We do have elections, but at least they are nonpartisan. And the judges are appointed to a specified term of years. They don't serve indefinitely, as they do in the federal system. When the Judicial Council of Idaho evaluates candidates or applicants for appointment to judicial office, they ask certain fundamental questions. What kind of cases have you personally handled in your practice of law? Have you ever personally observed certain kinds of cases? What kind of legal writing have you done? But then they also go on to make decisions based on enunciated standards, integrity and moral courage. On the legal ability and experience, not just who did you know who managed to get the numbers here on a given day. Intelligence, pretty important. Capacity to be fair-minded and deliberate. Industriousness and promptness in performing duties. We want deliberate courts, but we don't want courts that delay on purpose. Compatibility of personal habits and outside activities with judicial office. Capacity to be courteous and considerate on the bench. People have faith in government when government officials are courteous to people. Very important. I remember a case in the Court of Appeals. It was a fairly small case in terms of legal import. A pro se litigant, that is somebody just representing himself, appealed to the Court of Appeals from an order of the district court requiring that he comply with a law which was to pay for a certain permit to operate a business. It was $10. To him, it was the principal thing. And he thought government was, in general, was corrupt. And he delivered a kind of impassioned speech in the Court of Appeals that he didn't want the government to be telling him he had to give $10 for the right to operate his business. Well, he was unsuccessful because there are reasons why there are fees and permits. And we don't make up laws. The law is clear. But after the argument, both sides, we did what is an Idaho tradition. The judges, with our votes, we step down from the bench, walk around, and we shake hands with each of the people who has delivered an argument. And this fellow, who had been full of sound and fury, cheered up. And I shook his hand. He said, "Nobody ever did that to me." That's what the case was about. It was about a person seeking vindication of his individuality and his dignity as a person. Well, all public officials need to remember that. So the law has to be accompanied by certain personal characteristics such as integrity and considerate behavior. And also, judges have to be good at legal research and writing, needless to say. Well, I've already mentioned that the legislature, 2 going on 3 sessions, will change the system. So if the governor, if he doesn't like a certain slate of nominees, and ask for more. So the governor finally gets to a person he or she wants. The 2023 statute did a couple of other things in trouble. One is, you probably noticed this, in the midterm elections coming up, which is when the judicial elections also, that judges who seek to be retained in office are not supposed to be identified as judges on the ballot. Well, not very people know judges by name. So it means that the judges have to get out a campaign. They have to do things to get their name identification. Well, that's not very good for judicial impartiality and judicial independence. This is part of a national trend. A lot of money is coming into judicial elections because of partisan interest. In the last 2 biennial sessions of biennial intervals of judicial elections, huge amounts of money, hundreds of millions of dollars have been spent. More than $100 million was spent just in Wisconsin 4 years ago, and similar amounts spent in Pennsylvania a couple of years ago. Why? Because the Democrats wanted a Democratic court and the Republicans wanted a Republican. I remember in my service in the JAG Corps, talking to people who had served overseas, and they were astounded that in Iraq, for example, judges would say what sect of religion they were affiliated. Yeah, you could be a Shiite Muslim or you could be a different sub-party, but that's it. And litigants knew, they had lawyers, but they knew when they went before a judge, they were not going to get an impartial judge. They just knew that. Well, I hope we don't go that way. In Idaho, thus far we have not. The influence of money has been a real cancer on the judiciary, nationally and in many states. Fortunately, we are not quite at that precipice yet. But Sandra Day O'Connor, very strong, authoritative member and the first woman on the U.S. Supreme Court, where we expect judges to be accountable to the law rather than to political support. But elected judges in many states are compelled to solicit money for their election campaigns, sometimes from lawyers and parties appearing before them. Whether or not those contributions actually tilt the scales of justice, 3 out of 4 Americans, which is citing some empirical data here, 3 out of 4 Americans believe that campaign contributions affect courtroom decisions. The perception that justice is for sale will undermine the rule of law that courts are supposed to uphold. In this environment, we might ask, do people care? Shrug their shoulders. Many people who are powerless in society, they just assume everybody is corrupt. Judges too. Judges are taking money so far. That's the way of the world. Many people think. They're all politicians. They're politicians in black robes, and therefore they take money and they're subject to corrupt influences, just like everybody else. Well, I can tell you from my personal experience, I've had people tell me that about me. You're just a politician in the black robe. And it's hard to answer that. It's hard for judges who are disciplined, who have emerged from a merit selection system, who care very deeply about the rule of law, it's hard for them. There was a survey done a number of years ago by Xavier University about the judiciary and popular perceptions of it. They found out that 85% of citizens, respondents in the survey, did not know what rule of law means. That's not surprising, really, because most folks think it's all people against people. It's all people. The rule of law is people. 75% could not answer the question, what does the judiciary branch do? Imagine. What happened to civics education in this? What does the judiciary branch do? And 62% could not identify what happened at the Constitutional Convention. That's only a little more difficult than the question, who is Verity branch to? 62%. They have a lot of ground to cover in civic education these days. Well, I think many folks assume that courts act on personal impulse or political preference. And they'll go to an outcome that is satisfying to them, and then maybe they'll sit down in their chambers or with the help of some law courts, they'll write up some kind of a rationale for it. But they jump to the result first. Why? Because that's what they do in their own personal life. They haven't gone through the process of becoming a judge and so on. And judges aren't perfect. But they're not supposed to jump to personal preferences and then try to think of some legal justification for it. It's sometimes hard for people to understand the decision-making process because it's obscure to them and not fully elucidated by the media. Let's take the case from 3 days ago. Learning Resources Incorporated versus Trump. This is the tariff case. We know what happened in the tariff case, or at least we think we do. Many people thought, well, the courts have many conservatives on it. 3 of the members have been appointed by the president. They're just going to roll over and approve the president's exercise of a tariff-fixing power. Or they think tariffs are a good thing. As a matter of policy, we should have tariffs actively involved in the exercise of foreign policy. Those are all central puns on the document. What the courts must do is says, what is the law? What is the law? And the constitutional standard and the statutory standard, and then to the Congress. What Congress did subject to review for conformance with the national constitution. Well, there are 2 provisions of the national constitution that bear on this. One of them is that Congress has authority to collect taxes, duties, imposts, and excises, and that includes tariffs. It's Congress. It's called the International Emergency Economic Powers Act. Too lengthy to be capsulized here on the screen. But it's an emergency powers and certain guardrails written into the statute. And so the question for the Supreme Court was not, are tariffs a good idea? Are they economically sound? Are they politically favored? That's not the issue before the Supreme Court. The question is the president exercising a power consistent with this International Emergency Economic Powers Act? And, 63 votes, the Supreme Court said no, the president is acting outside the bounds of that statute. Great hope. Now, Justice Kavanaugh belongs at the center, but he wrote a separate opinion, said, well, but there are other statutes, and maybe the president can proceed under those. which I think the president has now announced he intends to do. But the principal other statute is one that gives the president temporary authority for 150 days. After that, any tariff imposed must be enacted or extended by the Congress, exercising its constitutional role. Well, the president doesn't like that, but nevertheless, that's how our system works. The Congress is given a power. It will be, its law will be read by judges who are impartial and independent. That's 1787.
So, 150 days.
We're running close on time, so I'm just trying to mention a couple of other things. And I'll say one more. I hope, and a very distinguished journalist here, that the media can be encouraged to go beyond resultant reaction coverage of judicial decisions. Get beyond resultant reaction and tell the public what the judge has said are the reasons for his or her decision. Don't shove it aside and say, well, it's all legalese, it's too tough for me to explain. Live up to your responsibility in a democratic society. Inform the public. Lawyers should educate their clients and participate in things we have here in Moscow. Law Day and Constitution Day program. Teachers in a classroom should explain the uniqueness of the Constitution and the judicial in civics class, not just treat it all as politics. Because it isn't. That's the American difference. That's the 1787 difference. We should discuss concepts of judicial independence and impartiality in the classroom. And citizens, including citizen groups like this, League of Women Voters, can invite judges to speak at organizations and service level and ask them to explain what they understand about law-based decision making. Not what do you think about a certain subject area, but what is the law and how do you reason from the law to ask them. Probably be good for them to go through the discipline of explaining that. And look for reliable sources of evaluations of judges. The Idaho State Bar publishes evaluation by lawyers. Lawyers, they know. They know when a judge is a good scholarly judge or an independent judge. These surveys are published by the Idaho State Bar, but they don't receive very much notice in public meetings. Well, let me conclude with a couple of quick aphorisms. One of the members of the U.S. Supreme Court now is Justice Burnett. Brilliant person, former dean of Harvard Law School. She's now on the Supreme Court. But she used to be, in her youngest days, a law clerk for Thurgood Marshall. Thurgood Marshall went to London at a big meeting of the British Bar and the American Bar. Caden's law clerk went to. And at that meeting in London, Prince Philip, husband of Queen Elizabeth, was present. And he had kind of a sardonic way about it. And he said to Thurgood Marshall at one point, I don't know if you would be interested in hearing my opinion of lawyers. And Marshall said, and I don't know if you'd be interested in hearing my opinion of princes. That is 1787, all over again. The transition from a society structured by status and hierarchy to one characterized by opportunity within a rule of law safeguarded by independent and impartial judiciary. The other story is a personal one. A number of years ago, I went to India on academic exchange. I had dinner with some lawyers in Mumbai, advocates. There was great interest at that time in The Microsoft antitrust case. Some of you may remember that. And one of the, it was extremely interesting that that case started in a federal district court with one federal judge. And one of the lawyers at the dinner table said to me, Ron, how much money is involved in that case? I said, well, I don't know. Probably $1 billion. Don, said another at the table, why has that judge not been bribed? It's a simple matter of economics, Don. Well, I was taken aback, questioned, tried to explain a little bit about impartiality and independence. I guess I was stuttering a bit. And the fellow who asked the question initially then, I remember he just kind of laid his hand on the table on top of him. He said, well, no, America's a different country. I said, yes, it is. Thanks for being here today.
Out of our official time, Donna said she's going to say and answer our questions. So just one quick lead announcement, which is that as we're here, the mayor is giving a state of the city address at, I guess, the Chamber of Commerce, and that will be posted on YouTube for you to watch.
What are they giving?
I'm sorry?
Well, when? The same time, right now.
Yeah,
If
right
you
now.
watch it on YouTube.
Okay.
Are there any other announcements?
Next week,
You want to announce next week's? Oh, next week. You want to move that? No, I don't think that you will. Okay, never mind. Just check your email. Yes. Finland 360.
Yes.
You said that. Oh, it's the school. It's your school. You want to talk?
Well, we have some people talking from the community schools on how people can be involved with the community schools and how there's this partnership of good things going on.
Yeah, Moscow School District.
Yeah,
Next week, it'll be really good. For 3 people.
Yeah, 3 people. Brian Smith is one of them. He's got 2 other people.
Well, you've all been very patient. If there are some questions, we'll give it a try. Yes.
Okay, you said that the Trump overrode the decision that the tariffs should go back to the Congress, and so they were illegal, and then he said no. You said he had 150 days, and the law he invoked gave him 150 days grace. What's going to happen after 5 months? Will we?
Well, the question is, under the statute that President Trump had not relied upon, but could.
Oh, I bet he did.
Could have, yes. But he is expected to. And that statute, which is designed to address emergency situations, has a 150-day deadline. After which, any tariffs announced by the president are null and void, unless Congress has then enacted such a tariff or extended the time. It's an action of Congress that we need.
So did he acknowledge that? Or the lawyers acknowledge that?
I think so. Yeah.
So in 5 months, we might have some chance.
Unless Congress might disagree with us, or disagree with anybody here who doesn't like those tariffs. It's a congressional issue, according to the Constitution.
Yeah, but he did keep it that. I have a question.
Here.
I'm wondering what the rationale was for overturning the precedent of Roe v. Wade. How did the justices justify overriding that precedent?
Okay. That's a difficult one. Because many people approach it from the standpoint, do you agree with Roe v. Wade or do you not agree with Roe v. Wade? and I suspect that judges being human are aware of those contrasting feelings. Abortion is never mentioned in the United States Constitution. The Constitution is just simply silent. Now, what the court in Roe v. Wade did was it reasoned by analogy to some other earlier decisions that have been made based largely on due process arguments. State statutes against anti-miscegenation of marriage of people of different races. There were laws against that in many southern states. The Supreme Court struck that down. It also struck it down on the equal protection grounds. And there are one or two others. But this is the court analogizing to its own earlier decisions. The argument that was made against legalized abortion said that was just judge-made law. There's nothing in the Constitution, there's nothing in the text or reasonable inferences out of the text of the Constitution about abortion. It's just the Constitution is silent. And if the Constitution is silent, then it's a matter left to the states. And so that's what the majority decided in the case several years ago, overturning Roe versus Wade, just saying it was an incorrect decision, which the courts ordinarily should not do. But the court said it was an oversight, it was an egregious oversight. Not to look at the fact that the Constitution has no text regarding abortion. So it was left to the states. The states may outlaw, may regulate, may allow abortion. It's a state issue. Over here.
What's your take on the idea that a couple of recent U.S. Supreme Court appointments were vetted based on what the Federalist Society knew they were going to rule on abortion, despite their declarations during the confirmation hearings that they would be impartial, and I think we're under oath, right?
Well,
Use the microphone, please.
I don't quite have a comment on that fourth aspect of the question. The confirmation process in the United States Senate for Supreme Court nominees or any federal judgeship that is an Article 3 judgeship is imperfect. How can you do it any better? How can you assure the independence and impartiality of the judiciary where somebody has to make an appointment? Who's going to make the appointment? The governor of the state, the legislature of the state. Actually, there are a couple of states where the legislatures make appointments of judges. Or in the federal system, if the president is to make the appointment, subject to confirmation by the Senate, how can we assure ourselves that the president will act upon merit selection principles or that the Senate will? Very difficult. The Federalist Society, which was founded several decades ago, is a politically active organization. No question about it. And they have pushed for appointments of judges who are strict constructionists of federal and state constitutions, especially the federal constitution. And many judges have been members of the Federalist Society in times past. I think that's questionable. As a judge becoming a member of any organization that has a political viewpoint. But it's not just on the conservative side. One of the awkward things that Justice Ginsburg encountered was that she, in her practice, was counsel or associate counsel for the American Civil Liberties Union, and she kept her association with the ACLU even after she was on the Supreme Court. So the system is not perfect. We should insist that it be more perfect, We understand that human beings have frailties. Yes.
Go ahead.
You cite the Federalist Papers for the reason for the precedent for following precedent in courts. Is there statutory language that says there should be, that precedent should be followed?
Congress has adopted the American Bar Association standards for impartial judging. And we also have, in the Constitution, the 14th Amendment, we have the equal protection provision, which actually has some play here. Because if people coming to court at different times might receive different decisions from different judges, then somebody being denied the equal protection of the law. So adherence to precedent is not only a normative standard with an ethical foundation, but it does comport with the equal protection argument of the 14th Amendment of the Constitution.
So my concern is with a lot of the immigrants to this country that are stuck in a system that maybe we don't have enough judges to hear their cases. Can you address how the number of judges are decided? Is that in the statute?
Well, the
Because
immigration
we need
system-
more judges, it seems.
Well, the question is about the number of the capacity. We have judicial capacity to handle immigration cases, and we don't have enough capacity. It's up to Congress to provide that
Is
capacity.
it Congress?
Congress is not interested in providing that capacity, unfortunately. So now the judges we're talking about here, for the most part, are not Article III judges in the judicial. They're judges under the executive branch. They're administrative law judges. But we don't have enough of them. There's some question about whether they can be impartial the way that Article III judges are expected to be. But we don't have enough judges. And we don't have enough lawyers for all the persons who are entitled to some kind of legal representation. So it's a defect in our system. It's caused cases to be backed up and caused lawless actions to go on unchallenged.
I think we need to wrap it up, but
I just had one more question. But how did it happen that they took the guardrails off the president's, that he's not able to be charged for anything, any crimes while he's in office? Because that's not doing the Constitution.
I'm afraid that's a subject of a whole different. Well, I think what the Supreme Court did is somewhat misunderstood. Partisans have said, well, the Supreme Court gave President Trump immunity for almost everything. But that's not really, if you read the decision, that's an important thing to do. Actually, look at the words of the Supreme Court, or any court in any decision. They set up, in essence, a three-tiered system, where some acts of the president are core to the institution of the presidency, and some that have implications for the presidency and separation of powers. And some acts that simply, there is no immunity for. You can say, there's not immunity for everything. And so maybe we can have another session on that. What is the meaning and what's the dimension of immunity? Presidents do not have broad immunity as certain pundits